I'll do my best. Brenna's a lawyer and an academic. I'm neither of the two, so I'll try. Good afternoon. I want to first thank Trenton and Deepa for this wonderful invitation and for bringing this panel together. It's really our honour. A very warm welcome to Sylvia McAdam, in particular, who's travelled so far to be here. I'm terribly sorry not to be physically present, and I hope that these brief comments will in some way add to the discussion this afternoon. I am a lawyer by training and now a legal academic working in the UK. While I've been in the UK for over a decade, I grew up in British Columbia and lived in various Canadian cities. Growing up as a South Asian in British Columbia, I was quite attuned to the ways in Canadian multiculturalism was built on the erasure of Indigenous presences and history, and also served to essentialise and mark out racial difference amongst immigrants of colour. All across Canada since mid-December, Aboriginal peoples and their non-Aboriginal friends, comrades and allies have been making noise. The irrepressible sounds of native drums and songs have been reverberating through shopping malls, streets, university campuses, and on the steps of legislative buildings. A multitude of other forms of political expression, blogs, online newspapers, journals, newsprints, and video footage of speeches, talks, and demonstrations are awash on social media networks and the internet. On December 11, 2012, Chief Teresa Spence of the Atwater Nation began a hunger strike in protest of Bill C-45. Chief Spence demanded a meeting with Prime Minister Harper, and significantly for this paper, the Governor-General of Canada, the Queen's representative. This particular demand is one that is part of a long relationship between First Nations and the British Crown, one which, despite the devolution of parliamentary power to the Canadian state in 1867 and the patrician of the Constitution in 1982, remains vital in light of promises that were made by the British Crown to the First Nations, either in the forms of treaties or other obligations. Much could be said of how Bill C-45 and other proposed legislation makes a mockery of the Crown's duty to consult, and indeed in December, for those whose minds quickly lurch towards thinking about legal liabilities and remedies, it seems that the Jobs and Growth Act 2012 quite obviously violated the duty that the Crown has to consult with First Nations on matters that might affect potential right claims or indeed existing Aboriginal and treaty rights as protected and recognised by Section 35 of the Constitution. A duty to consult that was hard-won and parasitic to some degree on the Crown's fiduciary duty that was first recognised in Goring versus the Queen, 1984, and elaborated upon since then in numerous cases and legal commentary. In this presentation, I will focus on the recognition of the Crown's fiduciary duty as an important example of a legal doctrine that exposes a fault line between a colonial settler legal regime and the assertions of Indigenous sovereignty and self-determination. My main point is that even the most progressive legal doctrines are rooted in the assertion of colonial sovereignty at odds with Indigenous self-determination and Indigenous sovereignty movements. As such, if Canadian Aboriginal rights jurisprudence is to remain an important site of political struggle, it remains to be decolonised. The recognition of the Crown's fiduciary duty marks a highly significant moment in Canadian jurisprudence on Aboriginal rights. The authority of the sovereign was newly conceived of as being limited by the duties owed to First Nations. The idea that the Crown owes a fiduciary duty to First Nations based on their historic relationship does not have absolute authority to govern its subjects as it desires, a defined feature of sovereignty is significant not only for the lives of First Nations communities, but for the very theory of colonial sovereignty itself. What is the nature of the Crown's fiduciary duty? It is a duty that is not confined to private law conceptions of trust law. It arises out of the specific history of the Crown's dealings with the First Nations. Broadly speaking, fiduciary duty comprises a number of obligations that broadly relate to loyalty or faithfulness. The term derives from the Latin word fidus, faith, and fiducia, trust. Fiduciary duties can apply to people who are not trustees per se in the private law sense. The word fiduciary means trust-like in the broader sense of the verb, to trust. The term fiduciary possesses a core meaning that a person in this position has a duty of loyalty to another person or body. The whole idea of a fiduciary duty is grounded in morality. Essentially, the Crown's duty in Gurren versus the Queen was based on the Indian Act scheme, arising out of the historic need to protect First Nations from unfair bargains with third parties. The court found that the Crown must act in the best interests of the First Nations, in specific regard to dealings in reserve land in this instance, as to, quote, prevent Indians from being exploited. The doctrine of fiduciary duty has developed in a number of cases, and there is one other that I would like to briefly analyse, which is Wawakam Indian Band versus Canada. This judgment once again involved reserve lands in British Columbia. In this case, the SCC held that there is not a universal fiduciary duty owed by the Crown to the First Nations, but there is one that is specifically tied to discrete issues, such as the surrender of reserve land. But the main point that I wish to draw out here is the dramatic sleight of hand that occurs throughout the judgment, which is the creation of reserve lands in British Columbia during the 19th century. In British Columbia, no treaties were signed with First Nations. Nearly the entire province was settled through the outright appropriation of native land. The survey of the land and the techniques of mapping employed were premised on total erasure of Indigenous relationships to the land. Sorry, that's... It's so unjust. Okay, so the court describes the creation of reserve lands in entirely positive terms. Quote, in this case, the intervention of the Crown was positive in that the federal government sought to create reserves for the appellant bands or provincial Crown lands, to which these particular bands had no Aboriginal or treaty rights. As explained, the people of Lac-Quil-Tac First Nation arrived in Campbell River area at about the same time as the early Europeans in the mid-1800s. Government intervention from 1871 onwards was designed to protect members of the appellant bands from displacement by other newcomers. When the YKK and the YK may have traversed territory from Campbell River area and Comox for thousands of years prior to the arrival of Europeans, their historic presence in the territory is entirely erased. And they become settlers to the area like any other, except that they have the benefit of the federal Crown as their protector. This sanitized rendering of the creation of reserve lands leads me to the fault line that I described at the beginning of the paper. The fiduciary duty discussed here is, quote, in keeping with the concept of the Crown, of holding the Crown to a high standard of honourable dealings. The honour of the Crown is rooted in historic and ongoing assertion of colonial sovereignty through an Imperial Act rendered First Nations its subjects, who it had a responsibility to protect. And thus, despite the significance of limiting the sovereign's power in relation to the First Nations communities, the very basis of the fiduciary relationship is, like so many other significant advances in the realm of Aboriginal rights jurisprudence, marked by the continued assertion of colonial sovereign power that is upheld as legitimate and monistic in its essence. From an international law perspective, it is necessary to query, as many First Nations have done since the settlement began, the continued assertion of Canadian Crown sovereignty. The British Crown's obligations exist in law, but not in reality, and thus Chief Spence's refusal to meet Prime Minister Harper without the British Crown's representative present. The changes in parties from British to Canadian could very well be considered to be a breach of the treaty on the most basic contractual grounds. The Idle No More movement, with its various assertions of Indigenous self-determination, is vital in refusing this continued assertion of colonial sovereignty as legal and politically justifiable. In my view, the Idle No More movement is creating and has the potential to create more space for a practice of decolonization. The resistance of communities on the ground is creating space for more radical scholarly work that does not simply mediate Supreme Court judgments, which may be very progressive from the vantage point of the colonial settler jurisprudence, but do not put into question the legitimacy of colonial sovereignty, even though, as many critical legal scholars have noted, it is based on tautologist reasoning. And that is why the demand for Aboriginal self-determination, perhaps a sovereignty that is in its essence plural, is a good starting place. Thank you.